Construction Contracts Amendment Bill Committee stage.
I declare the House in committee for consideration of the Construction Contracts Amendment Bill. Mr. Chairman.
The House is in committee on the Construction Contracts Amendment Bill. The question is that Part 1 stand part.
Mr. Chairman.
The Honourable Dr Nick Smith.
Mr. Chairman, I firstly want to acknowledge the work of the Select Committee on this Construction Contracts Amendment Bill. It makes a number of changes to improve the disputes resolution process that was put in place in 2002. The first of those changes is to expand the dispute resolution process to include residential contracts. When we did a review of the Building Act, it identified the fact that there were many residential building disputes that would be more easily resolved by the specific processes set out in the Construction Contracts Act. The second change that it makes is that it includes the professional design and quantity surveying and disputes in that respect that previously were not covered by the law, and there are some also technical amendments that improve the way in which that disputes resolution system works, which overall, Mr. Chairman, has been good law. The reason I've chosen to take a call early in the committee stages is that members will be aware of a pretty significant debate that's gone on in the construction sector about the issue of retentions. And yesterday I tabled in the Parliament a supplementary order paper that makes substantive changes in respect of retentions and how they operate under law. This was an issue that the Select Committee raised during submissions, and given the fact that actually the SOP changes are in some respects more significant than the original bill, I think it is worth just taking a moment before the Parliament to note those significant changes around retentions, what they mean, and why the government thinks we should progress with these changes. Mr. Chairman, in the construction industry, it is long established practice, not just in New Zealand, but internationally, for retentions to be held after construction work is completed to ensure that if there are any defects or difficulty with the work, that either the main contractor or the principal is able to ensure that those defects are fixed. Sometimes, Mr. Chairman, those retentions are 5%. I have seen contracts have them as high as 10%. When you're talking about a construction industry that's currently riding in an all-time boom, about $15 billion a year, the amount of monies involved in these retentions come to many hundreds of millions of dollars. Now, one of the concerns the government has, particularly for the subcontractors, is that these retention monies can be misused by main contractors effectively using it as working capital for the next project. And the part that does not serve the public interest around that is that if another project gets into financial difficulty, the main contractor ends up in liquidation, then you can have hundreds of subcontracting businesses who end up as unsecured creditors who are subsequently not paid. And so the government has given consideration over recent months to whether we could have better law in this regard. It's interesting, Mr. Chairman, to look at international practice. If you look at the Parliament of New South Wales has recently passed law in this respect, and they have introduced quite a strict structure where retentions would have to be held in separate trust funds, separated from the main contractor and the subby, and would then be released when the work was found to be without defect or the like. And in other jurisdictions, you could set up a system. For instance, I'm responsible for running the tenancy bond system. And what we do there, Mr. Chairman, is that when a bond is required in a residential tenancy, that money is actually paid off to a government fund. And the government manages that fund, and in the event that there is a dispute and when the tenancy comes to an end, the government then refunds that bond. We've put a lot of work and there's been a lot of consultation with industry, Mr. Chairman.
Honourable Dr Nick Smith.
There's been a lot of discussion with industry, with subcontractors, with the banking sector about what would be the right response for New Zealand. Our view is that law reform in this area is required, and we're trying to find a balance about what would provide the right incentives for the management of risk within the construction industry, while at the same time trying to minimise compliance costs. If you impose excessive compliance costs, that is simply going to add to the costs of business, to the costs of building houses, commercial and infrastructure across New Zealand. What the supplementary order paper provides is what I would describe as a deemed trust model. And that is, it is not that the the main contractor holding retentions is going to have to set up a separate bank account, not going to have to set up a lawyer's trust account, but is going to have to treat retention monies as deemed as trust funds. That means that the main contractor will have to be far more transparent in the way in which they report those funds that are held in retentions. It also means that in the event of a liquidation, as occurred very publicly and controversially around the Mainzeal collapse, the deemed trust funds would have a higher security in a liquidation than other funds, i.e. those subcontractors would be above the unsecured creditors and would receive funding and payment for work that they actually did, providing it was up to standard and meet the normal tests. And that would be a huge relief to people that are caught up in liquidations of those sort. So, Mr. Chairman, I'd commend the supplementary order paper to the House. I think it makes a much needed improvement in where the risks should sit within the building and construction industry. The government has chosen an implementation date of the 1st of April 2016. We think that's a reasonable period of notice to be able to allow the construction industry to take on board this new legal framework for the way in which retentions are managed. Overall, what the government believes is this change in the law around retentions will see the risk around collapse in the construction industry fit more appropriately with the parties, end up with a more disciplined industry, require a more efficient, albeit cautious response to commercial contracts, and of course an ambitious of these changes is that we have less people in the building and construction industry end up having work done and not being paid for it. And so I commend the original bill, but also the supplementary order paper to the House.